Mr. Luisel. So the Vulnerable Adults Bill has been a long time in the making, with the public consultation on the draft bill having been conducted nearly 2 years ago. The bill is a welcome piece of legislation to protect some of the most vulnerable in society, but also raises difficult questions of the role the state should play in intervening in the most intimate of relationships and in interfering with decisions and preferences of an adult on matters of their own care. The long period of gestation for the bill reflects the delicate process of balancing protection and respect for individual autonomy and freedom. I stand in support of the bill and the principles set out under Section 4, which articulates the restraint and proportionality that should guide the exercise of the extensive powers under this bill. I have a few points of clarifications on the scope of protection offered by the bill, the mechanisms for checks on the exercise of powers, and measures for protecting vulnerable adults beyond those set out under the bill. My first point really is what I started this speech with. Why did it take so long to introduce this bill? What were the various considerations or challenges MSF faced in introducing this important bill? Next, under the bill, a vulnerable adult is defined as an individual who is 18 years old or older. Can the Minister clarify the rationale for setting 18 years old as the lower age limit for a vulnerable adult? The Children and Young Persons Act protects individuals who are under 16 years old. What are the forms of equivalent legal protection and recourse available to those who are between 16 and 18 years old? Next, sexual abuse is not listed as a type of abuse under Section 2(1). Instead, physical abuse is defined to include coercion or attempts at coercing an individual to engage in sexual activity. This definition of sexual abuse as being a subset of physical abuse is too narrow because not all sexual harassment is physical. For instance, vulnerable adults may be subject to verbal sexual harassment not amounting to coercion in engaging sexual activities. Can the Minister clarify the rationale for subsuming sexual abuse under physical abuse, and also clarify how verbal sexual harassment will be dealt with under the bill? Further, would the Minister consider introducing or including sexual abuse as an independent head of abuse? Similarly, the definition of abuse under Section 2(1) does not include financial abuse. There is also a lack of provisions in the bill that address financial abuse of vulnerable adults. Financial abuse, such as financial exploitation, is a significant problem faced by vulnerable adults and is a form of elder abuse recognized by MSF. A 2014 survey conducted by Trans Family found that 29% of elderly mistreatment in Singapore involves financial exploitation. There appears to be a gap in the current legal framework for addressing financial abuse and exploitation of vulnerable adults. For instance, finance-related offences under the Penal Code, such as theft, extortion, and cheating, may not be sufficiently nuanced to address financial exploitation in the context of an existing relationship of trust or dependency. Protection orders under the Women's Charter does not extend to financial abuse. The definition of ill treatment under the Mental Capacity Act, which protects mentally incapacitated elders from ill treatment by their caregivers or donees or deputy, does not include financial abuse. Will the Minister consider extending the ambit of the bill to protection against financial abuse in the future? What are the current legal protections available to vulnerable adults subject to financial abuse? Next, the Director and Protectors have extensive discretion and powers under the bill. Caregivers may legitimately worry about disruption and interference in their lives, such as the possibility of entry into their homes and premises. Excessive intervention may also further strain relationships between elderly parents and their children. These extensive state powers must thus be exercised with great restraint and proportionality. Can the Minister clarify what mechanisms exist for review and oversight of the powers granted to the Directors and the Protectors? Would the Minister consider instituting a formal approval or reporting process for the most intrusive powers exercised by the Directors and Protectors? This would include the power to remove an individual for assessment without consent, to enter premise, to remove a vulnerable adult from their place of residence, and to require medical treatment. Can the Minister also clarify the instances where the Director or Protector need not seek a donee or deputy's consent before assessing or removing a vulnerable adult under Section 6(2) and Section 10(2). Given that cases of abuse, neglect or self-neglect often occur outside the public eye, effectiveness of the bill, as Minister has mentioned, is contingent on detection and reporting of such cases. Will training be provided to frontline staff to sensitize them to indicators of abuse, neglect or self-neglect? I understand that the social service officers and other community partners can call MSF to report cases of vulnerable adult abuse. But vulnerable adults who are not in contact with community partners may fall through the cracks. Would the Minister consider setting up a public hotline under the Adult Protective Services for reporting vulnerable adult abuse, as has been done with MSF Child Protection Services Helpline? Further, can the Minister clarify the ways in which the Adult Protective Services are similar or different from the Child Protective Services? Will every case of vulnerable adult abuse be reported to the police? There is an existing mechanism under Section 8 of the Mental Health Care and Treatment Act that allows a magistrate to investigate a report from any person or police officer that a mentally disordered person is not under proper care and control or is ill-treated or neglected. Can the Minister clarify how this provision will operate in relation to the bill? Lastly, can the Minister also share the plans for ensuring successful reintegration and adequate care of vulnerable adults when they are returned to their homes from places of temporary care and protection? Sir, clarifications and suggestions for Ministry's considerations notwithstanding, I stand in support of the bill.